case.
Good morning, Your Honors. The matter before the court is the case entitled Thomas Ferrazza versus North Branch Fire District Number 1, case number 25 AP 008. Representing the appellant, Thomas Ferrazza, is Lance C. Shader. Representing the appellee, North Branch Fire District Number 1, is James A. Valente.
Thank you very much. Good morning, counsel. We'll hear from counsel for the appellant. First, of course, please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. My name is Lance Shader, and I represent the appellant Thomas Ferrazza in this matter.
Thank you.
Essentially, there are two areas which appellant is respectfully pointing out that the lower court has erred. So it's relatively straightforward. First is that the standard for motion to dismiss was not applied correctly. Essentially, for the purposes of a motion to dismiss, the movant's allegations are all regarded as true, and the respondent's allegations are considered as false. So there's no, for the purpose of that motion, there's no proof required. Of course, the plaintiff would have to meet his burden of proof at trial, but we're not there. And at this point, the allegations have been made. Statutory authority has been provided to the extent of 18 sites, and everything is laid out in the complaint completely. So we have a problem with that. Secondly, the lower court found that there's no standing, which I think is the little bit more complicated issue. The suit was brought under Rule 75, which is the codified version of the mandamus relief provisions from our past. And the lower court held that there's really no disagreement that Rule 75 applies. And we are in agreement that it does apply. Essentially, the court held that there was no injury personal to Mr. Ferrazza to allow him to have standing. There are not a lot of cases in the matter. I did point out the petition of Fairchild case and the Rutland cable TV case, which are older cases, but in those cases, the complainants had, in my opinion, less of an interest than Mr. Ferrazza has in this case. Mr. Ferrazza is not just a taxpayer. Mr. Ferrazza is actually billed for services dependent on usage. So the fire district handles the sewage for this area. And it bills its customers based on the amount of water that's taken in, and that's assumed to be the amount of sewage that's going to have to be treated going out. So the way that municipality or quasi-municipality is run has a very direct bearing on the services that Mr. Ferrazza would get, the fees that Mr. Ferrazza would pay, and to a much broader extent, sort of any environmental impact issues from the plant not being run correctly. But we think that there is really a much bigger issue of public policy here, aside from the legal arguments. The state does not have the resources to police every public official. And even when issues are raised to the Secretary of State, as I have done, or to the Attorney General's office, they relegate these issues to the courts, which is probably appropriate. That's why we're here.
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. Once public officials are voted into office, the courts are all that stand in the way of any lawlessness that may come up. My client is, in common parlance, a whistleblower. He's put his integrity and his money on the line to provide the court with this extensive laundry list of violations that not only affect him, but the community. And my concern is that the court would set the standing requirements for mandamus cases so high that Rule 75 is rendered useless. If this instance, and if Mr. Ferrazza doesn't have standing, then who would? These are egregious, outrageous examples, and they go on and on for pages. The electoral process isn't going to solve this because the voters don't know what's going on. If there's violations in voting processes, the legislature has acted already by enacting all these laws. So it falls to the court now, and all the appellant can do is lay these allegations before the court.
Okay. Okay.
Thank you.
Thank you. Your time has expired. We'll hear now from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. My name is James Valenti. I'm counsel for the appellee, North Branch Fire District.
Thank you.
Chief Justice and members of the court, may it please the court, while we don't agree with the assertions made by counsel for appellant, the more significant issue, which the appellant doesn't address and we raised in our brief, is that the relief sought here, even if these allegations were true, even if they were proven, is a novel delegation of authority that should be the voters' discretion into the hands of the court. And the proposal is to provide the court a name of a receiver to essentially usurp the power of a duly elected municipal board based on a roughly 2-year window of alleged illegalities that would invalidate the constitutional rights of the voters. And also under Article 8, elected officials have a constitutional right to be elected if they are appropriately voted into office. The statutes very narrowly constrain judicial power with respect to the composition of a municipal board. If there's an alleged electoral fraud, an action has to be filed extremely quickly. And even, I'm sorry, I thought one of you spoke. And even in that case, the only thing the court can do is refer the alleged election fraudster for potential prosecution and order a new election, not throw out the results and choose its own authority because in the words of appellant, the voters don't know what's going on. I have a feeling that if the members of the Constitution heard that, they would hear an extraordinary violation of the separation of powers and also a huge incursion into the fundamental purpose of Article 8, which is to protect the will of the voters. It's also notable that as of January 1st this year, the legislature has spoken about where statewide statutes can direct municipalities to act or not act through the new 24 VSA 1996 and 1997, the state ethics law, and that does require municipalities to adopt either ordinances or personnel policies or rules to provide for the investigation and enforcement of municipal ethics violations. But that delegation of authority to the municipalities is a confirmation that the intent of the legislature in giving the courts some power to intervene in elections, and I'm referring to the election fraud statutes I spoke of earlier, 17 VSA 2603. The legislature is also very explicitly circumscribing the state's authority to just make sure that the municipalities do something at their discretion so that there is some sort of municipal procedure in place. If the legislature wanted to provide some higher degree of power to courts to use Rule 75 to invalidate elections to replace duly elected boards, this would have been the perfect time to do so, and it did not. The last issue is there's no distinction here in the individual members of this 5-member board. It's essentially an effort which ignores whether some board members voted for or against certain actions and penalizes the entire group. And even if the appellee cites the Constitution are wrong, even if the trial court was incorrect in its exercise of discretion, there's still really no way to explain why an entire board should be thrown out because of alleged actions that require a majority vote, but which fundamentally members of 5-member boards are not individually responsible for. As a result of all of that, our position is that even if appellant is correct, what appellant was asking for from the trial court had fatal flaws. And for that reason, the trial court's order should be affirmed because there's no real benefit to sending it back down. It can't overcome the constitutional hurdles, which are frankly much more concerning. The other point I'll make is, oh, I'm sorry.
If your time has expired, thank you very much. Please, does the appellant have any time?
Appellant has no time remaining.
All right, please call a conclusion of the hearing.
The next hearing